people in the locality were referring to as Khuni Koti.
They were convicted in the media right on the word go.
July 25. Nearly 2 decades after the killings of women and children in Nithari shocked the nation, the Supreme Court has delivered a verdict that raises more questions than answers. The court, calling it a manifest miscarriage of justice, said that convictions, particularly in cases involving capital punishment, cannot rest on mere conjecture and that due process must prevail even in the most horrific crimes. Two people were convicted in the Nithari case. Moninder Singh Pandher, the owner of the D5 bungalow in Noida's Nithari, and Surendra Koli, Pandher's house help. In November 2025, Surendra Koli walked free because the courts could not prove him guilty beyond a reasonable doubt.
So, how did they go from being branded as monsters
and being awarded death sentences
to being acquitted?
To find the answers to this, we must first revisit the case. Here's a quick recap. On December 29, 2006, skeletal human remains were discovered in an open drain and an open strip of land behind Noida Sector 31's D5.
I was a young crime reporter, and the first day, the story really became big when those skeletal remains were found in Nithari near this house D5. Is it? I mean, I'm if memory serves me correct with my stories, it was D5, right? Which people in the locality were referring to as Khuni Koti. I still remember. So the first day those remains were found from that drain near that house, that white building. Uh, some of the senior reporters actually went on the spot, and I felt that being a crime reporter, I should have been there. That place had become sort of an event. People from all over the city were, not just journalists, but even others were breaching there just to see what's happening there. And one of the stories that everybody started to do within a couple of days was somebody coming from some part of UP, some other part of the country, saying, "Hamara bhi bachcha gum gaya tha." In the hope that there will be some investigation related to their missing child.
January 10, 2007. The case was handed over to the CBI, which filed a charge sheet in 16 cases for rape, murder, kidnapping, criminal conspiracy, and trafficking. February 13, 2009, a Ghaziabad court found Koli and Pandher guilty of murdering a 14-year-old and handed them death sentences.
What were the charges and what was the evidence collected by CBI at that point of time? CBI had the recoveries, which were made from the open area just behind the house of the accused person, and the confessional statement of the accused, which was recorded before a magistrate. And then in few cases, there was a DNA report that the DNA of a skull of a girl was matched with the DNA of the parents. So the identification of the remains also happened. But there was no any other independent evidence except for this. And one charge was resulted into conviction. Only one charge out of 16 was resulted into conviction. And they were given death sentence by the trial court, primarily on this three evidence.
The Allahabad High Court upheld Koli's death sentence but acquitted Pandher in one case, citing lack of evidence.
Out of 16, Only one incident resulted into trial at that point of time. One judgment was being analyzed by the division bench of the High Court, and only one judgment of a division bench goes to the Honorable Supreme Court. And a conclusion was drawn that he's a serial killer.
And suddenly there was this diversion of, sex racket uh, being carried out in Pandey's home. The other theory on Kohli, that he was sexually frustrated, he was impotent, those kind of theories. And the Kohli theory just fell apart. Again, when I traveled to his village, met his family, and his wife said that, I don't know what is the police talking. I've given birth to 4 children. 3 are in front of you, and one of them was a newborn baby in a lap, a few months old. And she said that 3 are in front of you, one died very very young. So what sort of a theory is this?
Koli was convicted and sentenced to death in 12 other cases, all based on the same evidence. He filed mercy petitions which were later rejected. Later, his death sentence was commuted to life imprisonment. In 2021, Koli was sentenced to death in the 12th Nithari case, while Pandher was acquitted. Come October 2023, the Allahabad High Court acquitted Koli in 12 of the death sentence cases and Pandher in 2, overturning the trial court's verdicts. 4 days later, Pandher walked out of Luxor jail.
Now the distinction is this: number one, when they analyzed the evidence of 16 cases, they found that there is a repetition of the same evidence again and again. That means if there are various statements, the confessional statement made by the accused person, they are exactly on the same lines. And they were in a language which was not familiar with the language of the servant, because servant could not have understand that language. 2, same servant during the course of recording of the statement made a statement about the custodial torture. He also makes a statement that I was forced to remember the confessional statement so that I go and repeat the same before every magistrate. Third, that the recoveries which were made at the instance, allegedly at the instance of these accused persons, they were also made while the discoveries were already initiated by the public at large and also the police. The discoveries were made of already discovered articles. So the skeletons were already being recovered. It was already recovered, then where is the question of further recovery? The police has already identified the place. The public at large, few of the public men were also permitted to reach that space. So the second division bench of the Allahabad High Court, while dealing with 12 cases, found that it looks to be a fabricated case.
We are very grateful to God and the honorable judges that after 20 odd years, we have gotten relief from the Supreme Court. And what the CBI said in the starting, that my father had done nothing, has come to foray, and it has come right कि उन्होंने कुछ किया नहीं है, and he stands acquitted.
Here's what the Supreme Court said while acquitting Koli. Crucial scientific opportunities were lost when post-mortem material and other forensic outputs were not promptly and properly brought on record. The investigation did not adequately examine obvious witnesses from the household and neighborhood and did not pursue material leads, including the organ trade angle flagged by a governmental committee. Each lapse weakened the provenance and reliability of the evidence and narrowed the path to the truth.
So first case now finally has resulted into life imprisonment. Second case has resulted into acquittal. And those are 12 cases. Now the situation before Supreme Court is that which one should we accept? The evidence is the same. So to make sure that people don't lose faith in the criminal justice system, there has to be an equality. So now Supreme Court, after analyzing the second case and also appreciating the dichotomy between two judgments, conflicting opinion, have come to a conclusion that the accused should be acquitted in the first case also.
A major point highlighted by the court was the failure of the investigators to probe a possible organ trade case to a conclusion. The defense highlighted that one of Pandher's neighbors was a doctor who was a suspect in an earlier case involving allegations of organ trade.
And I got a tip off from a source in UP police in the special task force that while we are not investigating this case, uh, there are certain inputs that suggest that this could be an organ trade racket. So I thought that this is perhaps the lead that I've got. Unfortunately, there was nothing to sort of corroborate this other than this little bit of a source information, but even the source did not have much details about it, because nothing of that sort of had happened that it would clearly suggest that it's a organ trade racket. But while we were sort of trying to gather inputs on this particular lead, the arrests had happened. Both Moninder Pandher and Surendra Koli were arrested, and they were produced in court, and the police had taken police custody for further interrogation. So we stumbled upon, me and my then colleague, who's been a dear friend, Shobna K. One of the reporters. Now she works with the Hindu. Both of us did this story based on that remand application that the police had filed, that amongst those skeletal remains, it's only the skulls and the limbs that have been found in that drain, and the torsos are missing. Police very smartly did not mention organ trade, but this was hint enough, because where are all the organs? The organs are within the torso, and that was, I think, with the lead that I had got through a source, and then this thing on record in court. Our editors went ahead with the story, and this was a nice 6-7 column flyer on the front page of Hindustan Times, and of course, it was a big news break, and everybody started to follow that lead and wanted to get more information if that could be the case. But I think that was the end of the organ trade angle in the investigation.
The Nithari saga casts a harsh light on India's criminal justice system, especially police investigations.
That this is a classic example of a collapse of a criminal justice system, where right from the registration of FIR till the conclusion of trial, there are errors after errors. And the unfortunate part is there is no accountability. There is no accountability of the CBI for not conducting proper investigation, for filing a wrong charge sheet, falsely implicating the accused persons. There is no accountability till date. And there are 2 people who have spent more than 13 years in custody. Second, there is no accountability of the judges who have convicted. That our investigating officers are not trained to be independent. Trained to be independent means their job is to find unvarnished truth in the matter. Their job is not to charge sheet accused persons. Their job is not to seek conviction of the accused persons. Their job is to find the truth. And when you find the truth, and when you find that, yes, the accused is innocent, then you should have the courage to file the closure report in the court. My view is even the first one should have been tried with the other. Then you would have come to know, then the judges would have come to know about the truth. That how there is a repetition of the evidence. Look, when you get the statement under 164 recorded in 13 or 14 different cases, there are bound to be certain differences between the statement. They can't be verbatim the same. This is not a cyclo-style statement. So when you take the same person again and again, there are bound to be some difference. So I would say that the first trial should have waited for the other investigation to be over. And then they should have tried all the cases together. The result would have been different.
One question that arises is why convictions in lower courts are many times overturned by higher courts when the case is the same and the evidence is the same.
The reason which I can tell you from my experience is that normally the trial courts take a very narrow view of the matter, talking about the sense of appreciation of evidence. Normally, they are on a very narrow platform, where they overlook a lot of things during the course of the trial. And they are also the courts which conduct the trial normally. So they are aware of the body language of the witnesses. They are aware of the scientific evidence which has been conducted. So therefore, very often we see that their mindset is a bit narrow. Their the standard of appreciation which they follow is also a bit narrow. But when the matter goes to a higher court, which is a more broader court with larger powers, with constitutional powers, there the courts normally apply a very stricter principle of appreciation. That even if there is a little bit of gaps or lapses, procedural lapses, then they take action and they feel that this is a case where the judgment of the trial court has to be overturned. So I think it's a matter of perception between two stages at the sessions court level and then stage at the high court level.
This case also raises questions about lapses in investigations, especially in high-profile cases. When investigations are timely, professional, and constitutionally compliant, even the most difficult mysteries can be solved and many crimes can be prevented through early intervention. It is therefore deeply unfortunate that in the present case, negligence and delay corroded the fact-finding process and foreclosed avenues that might have led to the true offender. Besides the Nithari killings, police investigations have also been questioned in other sensational cases. For example, the Arushi Talwar murder case of 2008, where a 14-year-old Arushi Talwar was found in her house with her throat slit in Noida on May 16, 2008. Hemraj, the house help, was an initial suspect but was found dead on the terrace of the same house. The case grabbed headlines once more when in September 2009 it emerged that Arushi's forensic evidence had been allegedly tampered with, while the pathology report went missing. The police suspected an insider job as the murders were done with a surgical precision and even branded this an honor killing. After many twists and turns, the CBI filed a closure report in 2010 pointing fingers at the parents. Special CBI Judge Preeti Singh rejected the closure report and summoned both parents as accused for murder and destruction of evidence. The court treated the closure report as a charge sheet under the CRPC. In 2012, the agency charged the parents with murder, conspiracy, and destruction of evidence after conducting narco and lie detector tests. The couple was convicted by a CBI court in 2013 and sentenced to life imprisonment. But in 2017, the Allahabad High Court acquitted both parents after the prosecution failed to prove beyond reasonable doubt that the Talwars had killed their daughter. Reports quoted the judges as saying that the evidence against the couple was circumstantial. The other high-profile case is the Sheena Bora case. In the Sheena Bora case, which happened in 2012, Sheena Bora, 25, went missing on 24th of April 2012. A month later, Maharashtra police found a decomposed body in Maharashtra's Raigad district. Bora was the daughter of media baron Indrani Mukherjee from an earlier relationship. Maharashtra police said that the charred human remains believed to be of Sheena's were lost, but weeks later they said that they were found lying in the CBI office in Delhi. August 21, 2015. Shamvar Rai, Indrani Mukherjee's former driver, was arrested by the police for possession of illegal weapons. He told the police about Sheena's killing 3 years earlier and Indrani's alleged involvement in the crime. Indrani Mukherjee, her husband Peter Mukherjee, and her ex-husband Sanjeev Khanna were arrested. Indrani, Peter, Sanjeev, and Shamvar were granted bail by the Bombay High Court. Both the Arushi Talwar and the Sheena Bora cases remain unsolved till date. The common denominator, however, in these cases, besides that they shocked the country, is that the investigation's case fell flat in a higher court.
I think I would say that there are primarily two reasons. First reason is I've seen in many cases that the investigating officers actually chase a narrative rather than the science. So a narrative which is built around the case is the one which they invariably follow rather than trying to find the unvarnished truth in the matter. So they have somehow, at a very, very early stage, they form an opinion. And once they form an opinion, if that opinion is erroneous on facts, then they start treating on that wrong opinion and ultimately prepare a wrong charge sheet. Second reason why there is a shoddy investigation is, which I have seen in these high-profile cases, is the trial by media, which has an impact on the mindset of the investigating agents.
Beyond the legalese and fine print, one big question remains. Who killed the women and children in Nithari? The parents of the victims, who were mostly from poor slum-dwelling families, have given up. What does that say about India?